For those of you who would like to share this program with colleagues or others, it'll be posted on our website later today along with a PowerPoint presentation. And we'll actually send the link out to that to all of you probably tomorrow. So again, welcome to the program. Focus on misclassification are your nonprofits, workers, employees, or independent contractors. I'm here today with two of my colleagues with whom I work very closely. To my immediate right, Dave Warner, and to his right, Brian Hudson. Dave and Brian are members of our labor and employment group here at Venable, and they both work very closely with literally hundreds of our nonprofit clients every year on every aspect of labor and employment law, including this issue of employees versus independent contractors. I also see some other members of our labor and employment group here in the room as well. This is it's a really important topic for nonprofits. It's a topic that every nonprofit seems to deal with at one point or another in time. It's an issue that's been around forever, and a lot of the law in this area dates back decades, but it's also an area where there's been a lot of new developments in the law. And it's an area where there is increased and heightened attention and enforcement both from the Department of Labor and the Internal Revenue Service. So it's an issue that you very, very much need to understand and be on top of. The consequences for making mistakes in this area can be extremely costly, as we've seen, unfortunately, with a number of our clients over the years. And it's an area that can be very confusing. Hopefully in today's program that we'll be able to sort through some of that confusion for you and make this a lot easier to understand. And like I indicated, we have a pretty substantive PowerPoint presentation. You have a copy of it, those of you here in the room, in the notebooks that are in front of you. And for those of you on the phone in the webinar, it was emailed out to you, and at least a link to it so that you can access that. A little bit about the logistics of today's program. Dave and Brian are going to be our featured speakers today. They're going to kind of bounce back and forth and cover our topic material today. For those of you in the room, if you have questions throughout the program, do not hesitate to raise your hand. We will repeat the question for those of you on the phone so that you can hear it. But don't wait till the end. We will have time that we'll reserve at the end for questions, but don't wait. Feel free to ask your questions throughout the program. For those of you on the telephone and on the webinar, there's a chat feature on the webinar for those of you who are logged into the web component where you can send questions through that chat feature. I'll be monitoring that, and I will kind of pose those questions to Dave and Brian throughout the program. And then at the end, we'll leave time for questions, and we'll unmute all of the phone lines so that you folks on the telephone can ask questions that way as well. One other thing, if you guys want to write this down, both in person and on the phone, we have a lot of great materials and resources on labor and employment issues for nonprofits, including some articles on this topic, as well as many others. In fact, just about every major nonprofit legal topic and employment and labor topic as it relates to nonprofits. We have about 500 articles and PowerPoint presentations on our website specific to nonprofits. If you go to this link, it'll be easy to find, and you can search by topic area. One of those topic areas being employment law. It's www.venable.com/nonprofits/publications. Venable.com/nonprofits/publications. And we're constantly adding new articles and PowerPoint presentations literally on a weekly basis. So a lot of our clients and others find that to be a helpful resource, so I wanted to share that with you today. With that, I'm going to turn it over to Dave Warner to get us started. Dave?
Great. Thank you, Jeff. There we are. So I just want to do a brief overview of the agenda today. We'll be starting with what I like to refer to as what's in a name. What are we talking about when we say independent contractor versus employee? And every lawyer's favorite answer, of course, is it depends. There are multiple definitions of an independent contractor. There's a federal definition, which has been evolving over time, and there's varying state definitions. And we'll spend some time today talking about Maryland's definition, which differs from that in D.C. and Virginia. There's a movement afoot in Virginia to make their definition more like Maryland's. The point of that will be that wherever you are, just complying with the federal definition is not going to be sufficient. We'll talk about avenues of enforcement. How do these issues arise for employers? And there's principally three, through government audits and investigations, through employees, sometimes unwittingly, sometimes intentionally challenging their status as an employee or independent contractor. And then, of course, our good friends on the plaintiff's bar often raise these issues in the context of litigation and trying to enforce individuals' rights. We'll spend some time talking about the consequences of misclassification. And as Jeff pointed out, there are many consequences, and many of them can be extraordinarily expensive. That's why this issue has taken on such prominence, both for the tax purposes. You have governments that are starved for income, so they're taking a very hard look at 1099 relationships, making certain that they're collecting all FICA, FUTA, state income taxes, and the like. And then we'll end with identifying and remediating problems, and we'll talk about some of the common issues that we see in our practice with different nonprofits and other entities, and some solutions to try and resolve issues when they arise. So, as we said, there's varying definitions, but there is consistency among the definitions, at least at the polls, between an employee and an independent contractor. And typically when I'm trying to explain the concept to a client, I use the example of two agents, one being my legal assistant and the other being the folks that mow my lawn. You have a legal assistant on the one hand that she comes to our office every day. She's at a computer that we provide, at a desk that we provide, at a chair that we provide, and everything she does throughout the day, she does at my direction, my instruction. On the opposite side, a clear independent contractor relationship is the outfit that mows my lawn. I know they're going to show up at some point during the week. I pay them $50. Sometimes it's 2 guys, sometimes it's 5. They bring all of their own equipment. Their workforce may be of somewhat dubious legality. But between those poles, there is a world of gray area, and that's where the specific definitions become so important. It's very uncommon that we get asked a question that it's easy to quickly slot someone into the employee or independent contract, and that's why the varying definitions become so important. But as Brian will talk about, even within these varying definitions, there are some consistent themes. And basically, the independent contractor relationship will turn on the question of control. Who controls that individual? And within that, there are issues of behavioral control and financial control. And those concepts have varying definitions within, whether you're looking at the IRS, the state, or others. With that, Brian, I'll turn it over to you.
You've got to remember to use the microphone at all times. Thanks, David. Good afternoon to everyone. Many nonprofits and organizations use independent contractors to supplement their workforces. And the main reason they do so is the convenience of it. It's a case where you can have a relationship with someone that's just about the work. And traditionally, it should be only work that isn't your work, I think is a good way to say it. This relationship is more convenient because things like there are no payroll taxes for an independent contractor versus an employee. An employee who works more than 40 hours a week is entitled to overtime, whereas an independent contractor is not. Benefits, unemployment compensation, workers' comp, those types of issues you shouldn't have to worry about with your independent contractors versus an employee. Those same issues, though, the same reasons that you work with an independent contractor in the first place, the convenience factors, are what get you in trouble, and why, what David was referring to, and Jeff, the different laws that cover each of those pieces. So we have tax law, federal and state wage and hour law, which the Fair Labor Standards Act is the federal version, things like overtime and minimum wage, and a whole panoply, I like that word, I don't know if it's accurate, but it rolls off the tongue, panoply of other laws, things like the Family Medical Leave Act, for example. So that if a worker needs time off under the FMLA, if they're an employee, they're entitled to it, under most cases. Independent contractors are not. So for all the reasons that it's convenient to have an independent contractor, if something comes up and you say, I'm sorry, Brian, you're our independent contractor, we can't give you time off under the FMLA, and then it turns out later you're wrong, that's where the consequences come in. The same if you aren't taking payroll taxes for Brian Hudson, and he's an employee, not an independent contractor. So each of those areas, as David mentioned, has its own test, and we'll start with the IRS. This is an old test, actually, although I still see it referenced all the time, the 20-factor test. There's 20-factor tests, 6-factor tests. I think there's a 13-factor test at some point. They all sort of overlap, is the good news, and they all have that control as a common element. So you'll hear us talking about the different tests. Try not to get too caught up in that as opposed to the substance of what each of the tests mean. I'm actually going to jump ahead. I told myself I wasn't going to do this, but I'll come back to this, although it's not easy to skip these slides around, because I feel like going with the test that IRS uses now, they broke it into kind of 3 factors, is a good way to introduce this concept. And then once I've done that, we'll talk a little bit about the Department of Labor and its standards. So which of these tests apply depend on what law you're under and what venue, what forum you're under. Is this an IRS audit, or is it a lawsuit by a group of employees claiming they're entitled to overtime? So it depends on those type of issues. As I indicated, the IRS test, the new test, breaks it up into these 3 issues of control: behavioral control, financial control, and the relationship, which is, again, a type of control. All of these sort of overlap. I'm going to walk through them, and you'll sort of see that they sort of overlap. In all cases, it's a matter of a totality of the circumstances, in most cases. I'll come back to that in a second. And so each one of these, you may hear one of the factors we're talking about and think, well, how can I have someone work for me as an independent contractor if I can't pay them an hourly wage, for example? I have to pay them by the hour. That's one of the factors we'll talk about. Keep in mind that you have a checklist, and it's the totality of the circumstances that'll be important. Jumping back to where I said there are some exceptions, David's going to talk in a little while about state laws. He mentioned Maryland. Some states, Maryland has one, Virginia has introduced several bills in previous years. Nothing in the district yet, where they basically make a presumption that someone working for you is an employee. So in those states, there are statutory tests that kind of trump this common law test. So all the factors we're talking about that would still apply perhaps in an IRS audit might be different under a civil lawsuit. So keep in mind your state laws are in play. And I'll just mention very briefly, there's something called the Payroll Fraud Prevention Act that was just introduced in April by, and I forget who introduced it, but it's similar to a bill that was introduced last session and that didn't get passed, that does sort of what these state laws would do, which is it sort of makes a presumption of employee status. It would require employers to designate employees as employees or non-employees. It's a new term instead of independent contractor, non-employee. And you have to give them a notice at the start of employment. If you don't, there are fines. So it's an effort, broader part of the government effort, which we'll talk more about in a minute, to kind of control and rein in this independent contractor issue. That's not in play yet. So like I say, let's start talking about the common law test. Behavioral control is the first of the 3. And that has to do with what sort of control do you have over the work being done and the worker himself or herself. Where the place of work takes place. Is the worker required to come to your organization's offices every day? Is the worker required to come to your nonprofit at a certain time period every day? David mentioned the idea of a lawn maintenance contractor or employee who's an independent contractor. You probably don't care when that person shows up. They don't have to be there at 8 a.m. to 5 p.m. As long as once a week, once every 2 weeks, whatever it is, they perform the final service. And so you have to look at your control over the final service versus your control over the means. So if you require the worker to show up at a certain place to perform the work at a certain time, that's the kind of control that makes it more like an employee, less like an independent contractor. Who assists with the work? If an independent contractor, if your worker needs someone to help them, maybe it's clerical, maybe it's actually performing part of the task, the envelope stuffing, whatever it may be, is that someone you provide, the organization or the nonprofit provides, or is it someone that you don't care who does it, as long as, Brian Hudson is the worker and he can get whoever he wants to perform this service for you at the end of the day. To the extent you have control over that, that's, again, a type of control that makes it seem more like an employee, less like an independent contractor. Training and instruction, how the task is performed is another one. If you have to train the worker, it's a good sign. And we'll talk again and again about how this is a whole group of factors, but there are a few that stand out amongst them. One is training. If you're training up your worker to do it our way, our association way, this is the way we do it, that's the kind of control that tends to raise red flags with an IRS auditor or a DOL investigator, for example. Rolling over into that is the issue of financial control. I don't want to lose place of our slides here.
Just out of curiosity, while Brian's advancing, how many of you here in the room currently have independent contractors in your workforce? That's a significant percentage. And as you can see, given the nature of the work that you all perform, already you're ticking a lot of the right or wrong boxes depending on how you're looking at it, because likely your contractors are working side by side with your employees, coming to your offices, coming to the same events as your employees. Just the nature of the work that you all do is very conducive to these types of issues arising.
That's absolutely right. Like I say, it sort of overlaps. So the second sort of classification or question the IRS uses is this idea of financial control. And so again, how is the contract being paid for? How's the worker being paid? Ideally, I think the best case scenario, it's basically a flat fee. You pay $15,000 to a consultant for 3 months worth of work. You pay the individual for a project so that that individual, that worker, has an opportunity for profit or loss. They can do it as quickly as they want and whatever means they want, using whatever tools they want. They provide the tools and equipment, for example, is one of the breakouts. If you're paying your worker only an hourly wage, if you're controlling how the worker does it, the worker can't really advance and do better or worse necessarily in terms of the compensation. It is what it is. As I mentioned, that doesn't mean there are independent contractor relationships all the time that use an hourly wage. Lawyers come to mind, in fact. But there are other control issues that aren't there, so it's a sliding scale. But to the extent that the worker has an opportunity for profit or loss, that's an important thing to look at. Is there investment in the job or business? Does the advertisement of services, which again is good because it crosses over into the third one, the relationship issue. But how does the person hold themselves out? Is there any requirement, this happens a lot, that the worker only work for our organization, only work for our association? You may not. Are you subject to our employee rules and our employee handbook? You're an employee. An independent contractor needs to be able to go out to the public and offer their services elsewhere. And as a matter of just practicality, it may be that you're requiring 40 hours or more of the person's time. That doesn't make the worker an employee. But if, regardless of the amount of work, that as a rule, you have that control over them. One way to look at it is, how reliant is the worker on you, on your organization for their livelihood? And we see it all the time, and that's kind of one of the tougher questions, because you have people you definitely rely on, but are they relying on you? If you said tomorrow, we can't use you anymore, David, does David advertise his services? He has other clients out there. He has a skill set. He's got his own truck or business suit or whatever it is, all his own equipment, his own tech, his own staff to go out and do things elsewhere. Whereas he's coming into your office. He has to be there a certain time every day. He's paid an hourly wage or a salary. You control the means by which he comes and goes, the work he has to do. He has to participate in meetings weekly. He has to provide reports in a certain format. All those types of issues come to play. The type of relationship...
Brian, can I interrupt you for a second?
Absolutely.
Just be sure to talk close to the microphone, because some of our folks on the phone are having trouble hearing you. They said kind of fading in and out, so just try to stay close.
I apologize. I think I went one too far. Relationship of the parties is a key one. There was a case, and I tried to find it last night. I couldn't find it, so I don't have it with me, but trust me, this case happened. It was a company that basically responded to pop-up ads. They had pop-up ads on the computer. You'll see them sometime when you go to websites. And there were workers who were classified as independent contractors. They had written contracts. They worked out of their homes on their own schedules, and basically they responded to a pop-up ad. When somebody clicked on one, the workers were the ones who then contacted Brian Hudson. Hey, I see you've clicked, or more likely Joe Hudson, my father. He tends to get into it on the computer, problems with the tech. But so they respond to it and make the calls. Seems like most of the detectors we've talked about, that person would be an independent contractor. But they were provided with a piece of software they used to interact with the pop-up ad. So that was one strike against them. But I think I was surprised to find they were employees. But the one piece I think it keeps coming back to is the idea of the relationship, the integral part of the business. And that's, I think, under all these tests, very important. Does the worker do what you do? In this case, all the company did was manage these pop-up ads. It was making sales to these pop-up ads. It had workers who were doing that work. A question I guess I would put to some of you, hypothetical question only for now, is if you have a worker, I've seen associations and organizations with someone who's like a membership coordinator, for example, someone who puts together meetings, someone who handles the mailing lists. That person may or may not be an independent contractor, but it's someone I think you want to think about, particularly on this idea of how integral are they to your business. A lot of times what I see, and some organizations have, is you may only use this person at some points in the year. Maybe you only have 2 annual meetings a year. So you need to bring someone in to manage that, the meeting, the relationship, the hotel, set up the conference room like we've got here today. And so is that piece of it handled by someone is that integral to your business? And I think the question could be yes. It may not be, but if you have someone who's doing that, doing the business of your organization, your nonprofit, and helping you get there, then that's, I think, one of the factors that's a strong check in the employee box. And there may be other factors that keep you from coming down on the side of employee, but it's something to be aware of and to pay attention to.
And just a couple of quick words. The telecommuting relationship is one where we see a lot of problems and a lot of issues, because I think oftentimes employers get a bit more aggressive than they otherwise would because, for example, they might not want to have to register to do business in California. And so if they just simply have a vendor that they use for certain things that works from their home, it's easier for the employer. The problem is if it's a circumstance that Brian's describing where you're providing scripts, you're providing software, you're providing lists for them to use, they begin walking and quacking like an employee very, very quickly. And the state enforcement agencies understand that, particularly on the unemployment front. So if you do have independent contractors that are in other states, but as Brian describes, are very integrated into the work that you all do, I would look very hard at those relationships and make certain that you're comfortable that yes, indeed, this is a true independent contractor relationship and not just a telecommuting employee.
Thanks, David. That was very timely. Allowed me to mess around with the slides for a minute and actually back us up. And I backed us up to for those who were on the phone. So basically the third, I think it's slide number 4, the 20-part test. And I say it's an old test the IRS uses, but I do still see it referred to all the time. Sometimes practitioners, I think, aren't aware that the 20 test isn't officially, but even the IRS still uses it. And I just want to point it out to you because it makes a handy cheat sheet. Later on, we'll show you another one we have, but it breaks out. I think we've talked about just about all these factors, and I won't read them all to you now. But the instructions, number 3 is the integration into the business. It breaks out a little bit more for you as you're thinking about, do I need to bring lawyers in for an audit? Do I need to talk to someone about Brian Hudson, my worker, who I think is sort of on the fence? You yourself can use cheat sheets like this. The one thing I think we didn't talk about is 19 and 20, the right to discharge or the right to terminate. I go kind of back and forth on that one. I don't know if David has a feel for it, because the idea traditionally, let me explain that first, is that a contractor relationship, you should only be able to break that if there's non-performance of the contract. 9 times out of 10, the independent contractors we see, and I'm using air quotes, I keep doing that for the folks on the phone, I just think it's fun, so you're missing that part, and I apologize. But an independent contractor, we'll see, but it's a right to discharge at will, just like you would an employee. I hesitate to bring that up because I don't think auditors and investigators focus on that as much anymore, because I think more real independent contractor relationships have that quality. Is my microphone cutting in and out?
I think it just...
Okay. Let me know. Start waving frantically if suddenly I get quiet. I'm hearing kind of a feedback a little bit.
Yeah, I would agree with that, Brian. And my experience has been that so long as you're doing the other pieces of the relationship correctly, that I'm getting concerned about the mics. Okay. As long as the other pieces are in place and that you've got a good, strong, independent contractor relationship, the fact that you're able to terminate that individual, with or without cause or with notice or for something other than breach, I have not seen that been outcome determinative. Now, that being said, if you're being more aggressive on is this person an independent contractor or not, and they're terminable at will, that's going to be a strike against that person being found to be an independent contractor. So it's still certainly relevant, but like any of the factors, it's not individually outcome determinative.
That's exactly right. Thanks, David. I agree with everything he just said. The independent contractor ideally is someone who you only break that relationship. Again, the contract is for a period of time. It's for a piece of work. And if they don't perform, you break it. Same thing with them walking away with a relationship. Again, ideally, you have to look at how practicable that is for your business. But if you have that built into the contract you have with your worker, it helps because it looks more like a real contract between two equals. I want you to come in and do bill stuffing for me. I want you to do my payroll every month. You can work out of your home. I don't care whether your office is in Maryland or in Virginia. I don't care what hours you do it, but I'm going to send you the data, and you're going to process our payroll every 2 weeks. We need a final product on the 15th and 30th, whatever it may be. But we don't control how you do it, what you do it, and here's our contract, and the only way that we terminate it is not at will, but if there's notice and if at a period of time or you don't perform, those types of issues. So look at it that way as well with your workers and your relationships all the way down. I've moved forward. This is the Department of Labor's Economic Realities Test. And it's very similar. I won't spend too much time on it because it covers the same issues, the degree of control, the workers' opportunities for profit and loss. Skill required is one we haven't talked about. And it does come into play. We had a case several years ago now, about 2 years ago, that I and another partner worked on with plumbers doing very basic plumbing work. And they came back. They had, again, contracts that said, I am an independent contractor. And the first thing the client did was yell at my partner and I for several hours about how could this be happening? Where's the fairness in all this? But it was a lawsuit where they wanted overtime. And they said, we're actually employees. One of the factors that worked against them was they were fairly low skilled. They weren't skilled plumbers like you have and that come to your home and charge you very reasonable rates to do work. They were just basically just bringing pipes into, it was I think real, either commercial or residential apartment complexes. So they're bringing the materials up, they're helping to install piping and things like that. Integral to the business also worked against them, but the skill factor came up there. So it's one that I hadn't mentioned before, and it's specifically spelled out in the DOL test. The permanence of the working relationship is another one that I think goes both ways. It's less of an issue because there are longer term, but I did attend an IRS kind of an informational session in 2010. One of the things they mentioned in terms of identifying targets for audits is if Brian Hudson has a 1099 in 2000, 2001, 2002, 2003, all from the same organization or the same nonprofit, the same entity, and he doesn't have anywhere else, it raises red flags. So the IRS actually looks for that. So it's something to think about. Again, sometimes the practical nature of the business, you have a payroll system you like, you don't want to necessarily break that. But something, again, as David was kind of saying, if you're on the fence with a worker or with an organization you work with, something to look at is that long-term nature of the relationship. With that, I think probably is a good time to have David talk a little bit about the state laws.
Yeah, and I want to focus first on Maryland because that's where I've had some recent experience with an audit of these issues. Primary point again here is to understand that the states are not restricted by the federal definitions, either the IRS definition or the Department of Labor definitions. So they have the authority and they have been implementing definitions that, while again are conceptually consistent with the IRS and DOL, they do have different points of emphasis. Brian mentioned before that one key aspect here is that in Maryland, employee status is presumed. And that doesn't sound like that big of a deal, but for practitioners like myself and for HR professionals, it's extremely important, because what that means is if you look at all of the factors and you come up and you say they're about equal, that person's going to be an employee, so that the employer and your nonprofit will have the burden of proof of being able to show that, yes, by more than 51% of the evidence here, this person is truly an independent contractor. So that distinction is an important one. Maryland has set up in COMAR, the regulations for the state of Maryland, a lengthy definition of the criteria that it looks for to determine if someone's an independent contractor or an employee. And the criteria fall within three principal buckets that you'll see there. And the first is, you'll see the quoted language, because I think it's important the way they phrased it, that the person is free from the employing unit's control or direction. So again, think of the lawn service company. The only thing that I tell them is mow my lawn. And other than that, I don't direct anything for them. So they're clearly independent contractor. But how many of you, when you're thinking about the independent contractors that you have in your workforce today, could consider those individuals to be free from your direction? And how many are truly just on a project basis of, here's the project, go do, tell me when it's done, and here's your fee at the end. And the practical realities is, in my experience in the non-for-profit space, is that very, very few independent contractors would be able to check that box. The second criteria is that the service being provided is outside the usual course of business of the employer. So again, if in the usual course of your business you are sending out mailings, you are holding events, you're planning events, to the extent you have independent contractors that are engaged in those types of services, that's a large indicia under the Maryland state definition that these folks are employees, not independent contractors, regardless of what we call them or how we compensate them. The last factor is the one that caught me by surprise during this particular audit, was because the Maryland Unemployment Commission really grabbed hold of it in a very strong way, is that the contractor is customarily engaged in an independently established business, meaning that's not enough for just it to be a person that would like to be paid on a 1099 or a consultancy, but that they have actually gone through the steps of establishing either a sole proprietorship or some other corporate entity, complete with employer identification number, et cetera. And the circumstance in where all this came up for a client of mine was a consultant shop. And they provide research in a particular industry. They send out research papers and the like. And they had an individual, a young person, I think he was in college, who served as a runner. And what he would do on a daily basis would come and pick up all their materials that needed to be shipped out and take it to UPS or FedEx or whatever they used. And they paid him on a 1099 because he didn't do much of anything else for them. It was a pretty simple relationship, and that's how he wanted to be compensated. It was easy enough for them to do it that way. They were audited by unemployment, and unemployment looked at this relationship and said, no, this person's an employee. Said, you all are in the business of producing these documents, that this is central. This is what you all do. And he's an integral aspect of getting them from you to the customer. Query, I mean, there's lots of other services that provide that same service, but in some regards, that was unemployment's point. They said, because here this person is doing it as an individual. They don't have their own business. They don't do it for other companies. You're the only person that they provide this service to. And your 1099 is being written on a Social Security number, not an EIN number. So ultimately, they decided that they were going to end that relationship and go with a different, courier service, because the courier service did have, a corporate entity that could provide the same service, and they could do it on a clean 1099. So these issues are very real, and I would say that unemployment is one of the primary areas where these issues seem to come to light. And with that, I will turn it back over to Brian to talk about the different avenues of enforcement.
We've now come to
before you do that, we do have a question from the telephone. Question is, bear with me. When we have certain policies and practices that need to be adhered to, that require that independent contractors must follow, does that pose a problem with the degree of control exercised over the worker? Should this be identified in the agreement with the independent contractor?
I think it would probably depend upon the nature of the rules that you're referring to, because obviously there are some rules of the road in the modern workplace that your independent contractors are going to be held to. For example, your policies on harassment and EEO and the like. Those are things that you can and should enforce against your independent contractors, because a failure to do that could give rise to liability to your nonprofit. Now, if the work rules are more along the lines of processes, meaning this is how we do certain work at our nonprofit, this is how members are brought in, here's how they're processed, these are the forms that you use to fill, et cetera, then that would be held against you and would begin to look more like a employee relationship. So it just really depends upon the nature of the rules that you're talking about.
And there was one other clarifying question. Someone asked, when you were referring to Maryland law and its kind of unique application in this environment, someone just wanted to make sure that if the nonprofit is based in D.C., but the independent contractor is living in Maryland and coming to D.C. to work, does that at all trigger that Maryland law?
No, I was concerned that you were going to say that the independent contractor is working in Maryland. If they're actually working in D.C., it would be the D.C. laws that would likely apply.
No, but what if the person's working from home in Maryland?
Oh, if they're working from home in Maryland, that Maryland law will apply, because the typical way in which this issue arises is the contract comes to an end and that individual applies for unemployment in the state where they reside and perform services, and there you are.
Supplementing what David said in response to the earlier question, one way that I've handled that before, we had exactly as David said, the client said, well, wait a minute, we have to have some rules, non-harassment. I believe in that case there were children, and so there were certain rules related to how you handle yourself around children. And they were having their workers, their independent contractors, sign the same agreements that were at the back of the employee manual. What we suggested in that case, just as David said, is that's an important rule that we don't want to exempt independent contractors from who are in your space, but we made basically a parallel set of rules, a parallel set of agreements. So it's not called an employee agreement, it's not the employee manual, it's just a separate set of rules that are specific to your independent contractors. In some cases that can be a way to handle it. Before we go on to the next section, should we see if there are any other questions in the room right now? Is this a good time? Yes, ma'am.
Hi, I used to work in Maryland in home care, and one of the big issues was our private duty members, which would contract with independent nurses to go out and do places. There was always a big discussion about, the core of the business was really placement of these nurses. And I'm just curious, for employment agencies, it's integral to their business that they make these contracts and make these placements. But we always kept running up against different problems in Maryland with, say, unemployment agencies raising questions about whether or not this is okay.
Yeah, let me see if I can summarize it. The issue is with regard to employment and staffing agencies and how those relationships are viewed by the Unemployment Commission or unemployment authorities, particularly in Maryland. And I would say it depends mightily on the perspective that you're looking at, because if I'm contracting with you for you to provide me with home care nurses, for example, for my business. I'm in the home care business and I need nurse staffing. If I have a contract with you and you're providing me the nurses, I've got a very strong argument that, as between the two of us, that you're my independent contractor. I think that line gets real blurry when you start talking about the relationship between the nurses who may have a contract with you as the staffing agency, because I could see arguments being made on either side as to, what is your business? Is it simply providing staff, or is it really that your core business is to have these nurses and to provide the care? And that's, I think, I could see the Unemployment Commission coming down on either side of that, depending on the circumstances.
We also have someone on the phone, and I don't want to make this too geographically limited, but someone was asking just to contrast kind of the general approach of the Unemployment Commissions in D.C. and Virginia compared to Maryland. And I apologize I know we have folks on the phone from New York and California and elsewhere, and we can't get too state specific, but can you just give a high gloss on that? Yeah, sure. And I can, in deference to our folks from California, I recently had an issue with them, and theirs largely tracks the federal law, which I found surprising, because usually when you're talking about the People's Republic of California, their regulations tend to be a bit more robust, I say, when I'm not being pejorative. Maryland, in my experience, has been the most aggressive with this presumption of employee status. As Brian mentioned, it looks like the Commonwealth is heading down that path, or at least there are legislators within Virginia that are trying to get there. But my experience has been that Virginia is much more like the IRS. And Brian, I think you were looking at the D.C. law earlier. Yeah, D.C., I would be willing to bet there's been a bill entered that mirrors what Maryland has done, but there is no act yet. So D.C. typically still follows the common law, if you will, control test that we're talking about, although I wouldn't put any money on that not changing at some point, particularly if in Virginia they pass the law that mirrors COMAR, the Maryland, because then D.C. is sort of surrounded by it. I will note that it depends on the state, I think, in some cases, or across the country. I think it was in Massachusetts just recently. There's an association that just lost in the past couple of days. They filed a constitutional challenge against one of these laws, I believe it was Massachusetts, that
makes the presumption of employment. And they filed a constitutional challenge, and I forget the exact nature of it, but that's a case where it tells me that Massachusetts is being more conservative, and they've actually filed the reason that the association was filing this lawsuit is they're the target of an audit, and they're being told that they've employed a bunch of independent contractors, and because they didn't meet some of these requirements, like having the worker licensed and registered, that these were in fact presumptive employees. So that's a challenge they just lost in Massachusetts.
And I think moving beyond just Maryland, I think Maryland's instructive though because it shows the direction that the law is moving. And in particular, I think it underscores the importance and growing importance of both the relationship and the financial aspects of the relationship. So that if you have a contract with a corporate entity, even if it's a sole proprietorship, that matters. If the individual, to Brian's point, can suffer a loss on the deal, that they can put in more time and effort than they get paid for, that's a big factor. And big factor under Maryland, it's a big factor under IRS and under the varying state laws. But I think what we're seeing is the law developing in that area because, again, the states are looking for tax money and they're taking a very hard look at these types of relationships. So while the laws differ, there are certainly some trends.
We have one more question. Someone from the phone wants to know how two particular factors would kind of factor into the analysis, if at all. One is they're requiring the association's independent contractors to use the association's travel agency to book travel to the association's events or just to come visit the office, et cetera. And secondly, providing, say, comped hotel rooms to the independent contractor as opposed to having them book their own hotel, pay for it, and then seek reimbursement from the nonprofit.
I think both of those probably lean you more towards employee because they're both a type of control. How far? I would, just speaking off the top of my head, using the travel agency doesn't seem, and I can't exactly articulate why, maybe David can, as much of an issue as the reimbursement of expenses, hotels and things like that. It happens all the time. Again, lawyers, we bill for expenses sometimes, but ideally, it goes back to that profit and loss. The contractor, the worker, has to decide what this project is worth. And if I have a plane ticket, if I have a hotel, that's part of my investment in the relationship, and I should have built that in originally as opposed to being reimbursed. So I think that's the way those would go.
Well, maybe a more general way to put it is, how about kind of the reimbursement of expenses generally? Can you talk about how that kind of factors in? Because that's a question we get all the time.
Yeah, sure. I mean, the short answer is that reimbursement of expenses is going to weigh on the side of employee status. The longer answer is, do many independent contractor relationships require or call for the reimbursement of expenses? Yes, they do. So in my mind, I put that in the category of something that will be looked at, and it's something that does, again, cut against independent contractor status, but is very seldomly going to be outcome determinative. On the travel agency piece, I wouldn't likely lose any sleep about that because it's more of a logistics issue. So that if you have a pre-existing relationship with the travel agency and that all of your folks are running their expenses and they're planning through a single point, it may just be administratively easier to say, we want you to do this because we want all of our people on the same jet, or we want to be able to coordinate rides and things like that. However, again, if I put my unemployment commissioner's hat on, I'm going to say, well, they're looking an awful lot like all your other employees. They're paying for their hotels. You're using your travel agency. So again, is it a factor? Certainly. Is it going to ever be outcome determinative? Likely not. Yep, sure.
Yes, David spoke a little bit earlier about telecommuting and some of the problems that may arise when the employer provides software and materials, and this may be indicative of an employer-employee relationship. And I was just wondering if there are any other red flags that could be raised with a telecommuting situation of telecommuting.
The question is, are there any other red flags in a telecommuting relationship in addition to the ones that I spoke about before in terms of providing software and other tools? And the answer would be that the red flags are going to be the same. It's just that they seem to come up a lot more often in a telecommuting relationship because I think people tend not to look at them because they think, well, they're not coming to my place of employment or to my office every day, so they're just an independent contractor. We'll just pay them on a 1099 and forget about it. But if it's a long-term relationship, if year after year we're cutting 1099s, if we're the only non-for-profit or other businesses this individual provides services for, so they truly are solely our agent. If they don't have an established business, if they're using their social as opposed to an EIN number, all of those factors come into play. And it's really, there's nothing necessarily unique about the telecommuting relationship. It's just where I've seen more issues arise because I think it's easier for people conceptually to think that this person's not my employee because I don't see them every day. So they don't, and I think that's why the issue gets overlooked as opposed to the issues being significantly different in terms of employee versus independent contractor status.
And David, to that, I've had several clients, probably 3 or 4 clients who've had telecommuting employees that brings up kind of a related issue, which is they were employees who worked in the office at one point. Several of them, at least 2, were estimators for construction companies, for example. So not directly applicable to y'all, but you can, it's someone who does work for the employer, and they decide, my husband was transferred to Norfolk, or I'm moving towards retirement, so I'm going to work a little bit less, and I'll start telecommuting. And so the client says, well, sure, you're not in my office anymore, so you're automatically an independent contractor. And it doesn't fit neatly in these. We may have it mentioned in a slide late in the game, but if someone has been your employee and you're turning them into an independent contractor, be very careful with that. It doesn't pass the smell test 9 times out of 10. They need to be doing something very different. And the fact that they're just working from home now would make almost no difference at all. That's one, you'll notice in the factors, what I call you isn't one of the factors. They don't really care about that. And the same thing with the telecommuting. It doesn't solve anything. It adds to the fact the control factors a little bit, but that's when I saw several times related to that. It reminded me.
Yeah, and we do see that a lot, particularly if people are either relocating or they're towards the end of their career and they want to throttle back and they say, well, can't I just consult? I'll work from home mostly. And it turns out what they do is they're doing exactly what they were doing before, but they're doing it maybe 20 or 30 hours a week as opposed to 40. But if nothing has changed about the services that they're providing, how they fit with your organization, the chances are they're just a part-time W-2 employee and not a 1099 consultant. So that's an area where we see this issue arise a lot.
Question on with going to kind of try to go back and forth between the folks on the phone and the folks here. We are getting a lot of questions, and a number of people are kind of posing particular factors. And of course, as you've already indicated, generally speaking, there are very few factors that are outcome determinative, and all you can kind of do is say which side of the fence these factors tend to fall on and how much weight they might carry. One question: if they have a contractor who occasionally attends kind of industry technical meetings on behalf of the association, is that something that would fall in favor of say a consultant who's hired because of expertise in a certain area and they're going to be kind of the emissary or the representative of the association at an industry technical meeting? Is that a negative factor, or does that weigh on the side of an employee?
Jeff, my answer to this one and all the other questions is it depends.
We need a slide that says that.
No, I mean, I think here, as always, it really does depend upon the circumstances surrounding that relationship. So, as you describe it, if it's really someone, I could see being able to set that relationship up in a way that you'd have a very strong independent contractor argument because, my instructions to you is, attend the trade show for us and bring back information. I'm going to pay you on a fixed fee. And that's what you do. If it's a long-term relationship, that this is just one aspect of it, I could see setting up the relationship in a way that it would look like a W-2. So, for example, if you say, go to the trade show and here are the 12 people that you need to talk to, and here's the information that I want you to extract from them, and here are the reports that you have to provide to me when you're done. And so it begins to go from just a very general assignment to a very specific assignment, then that begins walking and quacking like an employment relationship.
Yeah, I think that raises a really good point. It's something that I think folks forget about a lot, and that is that when you have certain factors that might be negative factors or might point toward an employee relationship, it's really important to be proactive in structuring that relationship at the outset to overcome those factors. So like Dave just said, if you have a negative factor, you counterbalance it with certain positive factors that weigh toward the independent contractor side. So how you structure these relationships from the outset can be very helpful. And as you know, you guys do that very regularly with our nonprofit clients. One other question. Any problems, and again, everything has to be taken in context, with independent contractors supervising staff, supervising employees?
I think it's on. Yes. That is one I've seen that, again, doesn't fit neatly into any of the particular factors, but I always tell all of my clients, I don't think I've ever made an exception to this, if you have an independent contractor, I'm using air quotes, who's supervising employees, that's a no-go. That's someone who, I think it goes to the integral nature of the business perhaps, because it's something they're doing that, it's not like a contract service. It doesn't feel like something that's a contract service. Often that's wrapped up, I find, in are there other individuals doing the same thing in the organization who are employees. I often see that where, I'm trying to think of a good example, accounting perhaps. You have someone who's doing accounting, processing bills, paying bills, and you have employees who are doing it, and someone doing it in a very similar circumstance, but they're an independent contractor and they're supervising a staff of employees. I would say even though it's not a determinative, outcome determinative factor, it's one that would be a bright red flag for me.
Yeah, and one comment on that is a major exception to everything that Brian just said, and I'm in complete agreement with him, is when you're dealing with interim CEOs or management services agreements. There we have seen and we've structured and defended relationships as independent contractors, even though they're sitting in the same chair that the former CEO or executive director did. But we have all the other pieces in place. We've got a rock-solid independent contractor agreement, so it's very clear what the relationship is, paying on a fee basis as opposed to an hourly basis. And most importantly, you go into that relationship with the understanding that it's temporary, and so you don't have the permanence piece. But even with all those pieces there, if that relationship extends beyond 3-6 months, would it be possible for the IRS to look at this and say, no, this person's running your business. They're not only integral, they're essential. I could see them taking that position. But to Brian's point, generally speaking, supervision of other employees is a major indicia of employee status.
And of course, in the nonprofit and association world, it's very common for nonprofits to bring in interim CEOs, to bring in interim CFOs. But generally speaking, you're contracting with companies that do that for their business, and they do it for lots of nonprofits. And they send folks, they handle outsourced accounting or temporary CEOs. And so certainly, when you have a company that does that for a business and it does it for lots of different clients, it's going to be a very different scenario. Do you have a question here, Dr. Page?
Yeah, getting back to the situation whereby you have an employee who wants a reduced schedule, and you're satisfied with that employee. Maybe the way to accommodate that is to agree to terminate the employee's contract and then enter into an independent contract.
The question is, if you have someone who is an employee and wants to go onto a reduced schedule, is one option to terminate them as an employee and enter into an independent contractor relationship. And the answer is you can, but there's several risks that are inherent in that. Because if really what's happening is that the employee is just throttling back, that they're going to be providing the same services they were as an employee, but now they're going to do it, say 20 hours a week as opposed to 40 hours a week, and nothing else changes about the relationship, highly likely that person's just a temporary or a part-time employee as opposed to a true independent contractor. Where we often see it is the exiting senior management, be it a CEO or CFO, that has a tremendous amount of institutional knowledge in their head that we want to have access to. Oftentimes what you'll see is they'll be terminated, they'll have whatever severance was in their employee agreement, and then a come-along consultancy arrangement that will say, we'll guarantee you up to X number of hours per month for this set figure of dollars. And that's something that's easily defensible because it's clear that the nature of their position is changing. I'm going from running this organization or running the finances to just being a consultant, that I provide information from time to time. It's not expected that I show up every day. And that's a very defensible relationship. So it is an option. It just, again, depends very much on the circumstances and how it's structured and also what that individual is actually doing for the organization.
Of course, it's a very common scenario with CEOs of nonprofits to enter in those consulting relationships. But of course, there's a new CEO that's come over and taken over that job. so it's a very different kind of relationship. There's also kind of a follow-up question that's similar, or kind of the reverse. If someone asked, if you take someone from who you're currently treating as an independent contractor, listening to Dave and Brian here and realize, oh boy, this person's really probably should be an employee. And frankly, you guys go in all the time and do kind of audits of our clients, and we'll look, to make sure people are properly classified as employees versus independent contractors, exempt versus non-exempt employees. If you realize you've done some things wrong and you reclassify them as an employee, what kind of liability is there for what you had done in the past?
Actually, let me pass on that question because we have a couple of slides on that very issue coming up in a few minutes. There's another question here.
Let's take one more question here, and then we'll keep moving on.
Some of the factors you discussed, how does social media with other people in the organization, or posting that you work as an employee, you don't work as a contractor, but you work as a particular organization? Does that come into play at all in this way, factor that this?
I've seen it more generally in terms of if you're holding yourself out to the public as an employee as opposed to as an independent contractor. A better scenario where I thought, and this may be, oh, I'm sorry, I didn't repeat the question. The question was with regards to social media and an individual who holds themselves out to be working with X association or X organization, either as an employer or independent contractor, and how does that factor into it? And the various tests do look at how you hold yourself out to the public. So I think the social media aspect is just it's a new way that's done as opposed to a Yellow Pages ad if someone was advertising their business, for example. So best case would be they have an EIN number, they're on Facebook or LinkedIn as Brian Hudson Consultants, and one of my clients is your organization. If all the other factors are there, but the person says, I work at X organization, or I work at, not a deal killer, but probably something that, again, when you're looking at all the factors, you might consider, if not having a policy or practice on it, at least when you have the person who's on the fence, making sure that's not a problem and it's defined in a defensible way.
Yeah, certainly. I think in terms of information that might be on someone's Facebook page or on their LinkedIn, I would feel much more comfortable if it said, my major client is, as opposed to I work at. And in my practice, in addition to the associations and nonprofits, I have a lot of government contractors, and the government contracting community is notoriously bad when it comes to independent contractors because it's a very small market in Northern Virginia, very incestuous. People go all over the place, and they have independent contractors that they provide business cards to. And to Brian's point, that's a major indicia of an employee or of an employment relationship. And in some regards, what's LinkedIn if not electronic business cards and electronic resumes? So I do think it's something, particularly as Brian said, if you've got people that are on the fence, that you may want to have a policy that says, if you're an independent contractor, you can identify us as a client, but not as a current employer.
All right, one comment and then we'll move on. Just as an aside, for those of you who are interested in kind of the various legal aspects of social media and what it means for nonprofits, this is an area that we have been very much focused on for some time now. And on that web link I gave you earlier, one of the topic areas is social media. We have a ton of PowerPoint presentations and articles on the subject, on the employment issues, employee privacy issues, things like that, and all of the other legal issues like copyrights, trademarks, defamation, privacy, etc. So if you're interested in that topic, you should check out those resources. All right, you guys want to move on?
Yeah, this is the portion where I get to scare you a little bit more, so I'll try to hurry through it, but it is important to know what's out there. The traditional ways that this issue comes to associations and organizations are still there. Jeff at the start talked about lawsuits and the civil suits. This is not a new issue, so that's still there. You may, for example, get a worker who comes to you who wants time off under the Family Medical Leave Act. You say no. They file a suit, and part of what the judge will decide if that case goes to trial is Brian an independent contractor or an employee? And if he's an employee, guess what? You violated the law by not giving him the FMLA. It may come up in a case like that. Often it comes up, where I've seen it probably most often, is the class actions for overtime. A group of employees, workers get together. They've been treated as independent contractors. They start talking to each other, or a plaintiff's lawyer, enterprising plaintiff's lawyer comes along, darn those lawyers, and puts the idea in their head that, you sound a lot like an employee to me, and so there's a class action under the family, or a collective action under the FLSA, Fair Labor Standards Act, for overtime. So it may come up in that context. The main thing I want to talk about here is how the government is getting more involved in it. They've always done these audits, but as I say, this is the part where we scare you a little bit. It's a growing issue of emphasis, and Jeff and David both teased this at the start. The government, frankly, is looking for money, and they see a lot of money being left on the table. At a IRS session in 2010, I mentioned earlier, they estimated federal losses of $2.7 billion a year due to misclassification. A GAO study from 2006 had like in a $3 to $4 billion range. So that's the government saying this is how much money we're losing by not going out and finding everyone who has an independent contractor who's actually an employee. So they're motivated. The slides talk about the budget issue. We all obviously know that the deficit's a big deal and budgets are shrinking. Money is being dedicated to this by the Obama administration to the DOL, $46 million in the proposed budget. In the continuing resolution that just passed in April, there's $21.3 million going to the DOL, particularly for misclassification enforcement issues. So it's that $15 million number that's budgeted for wage hour investigations, that's actually an increase from the previous budget. So again, at a time when everything seems to be shrinking, this is an area where the government says, we can actually invest some money here and get more out. Unfortunately, that's out of your pockets is what they're talking about. IRS is on the same page. These groups work together, and they work with the states as well. The Employment National Tax Research Program sounds fairly innocuous. It's a research program. What harm could there be in that? But what it is, it's a 3-year initiative that IRS has started where they send out 2,000 of these audits a year, randomly targeted audits. And I managed to avoid using the air quotes this time just because I forced myself. There have been IRS officials, former IRS officials I should say, who have pointed out that these are not actually randomly targeted. They're done in such a way as to focus on, guess what, nonprofits, smaller organizations. They're fishing. They're looking not just to get a little bit of money here and there, but can we find a pattern amongst non-traditional, if you will, employers and organizations that we can then dedicate our resources more effectively and efficiently. So what they're researching is, are there more of you getting it wrong than in another sector of the economy? I think that's the cynical but also kind of honest way to look at it. So those audits are out there, and that's, like I say, just to point out, I don't want to spend too much time so we can keep moving forward, but the government is motivated on it. I don't know if anyone here has seen one of these audits yet, but they're out there. I see Karen in the back. For those who aren't in the room with us, one of our partners, Karen Pass, is here, and she's pointing out the Department of Labor has created an app on the web that allows workers to track their hours worked with the specific idea that if it turns out that you are owed that time, look, we have a convenient way where we've collected that data already. We're all ready to go and file our papers against the organization. That's interesting. The states are also getting into this game. There are 37, last I checked, states that have basically work-sharing agreements with the DOL and IRS both. I think OSHA is involved as well. I have that somewhere, yeah, to share information so that if one of them catches you, and this applies to unemployment comp as well, they make sure all their friends know at the IRS and the DOL, and so it can all come crashing down. I haven't seen that actually happen too often, knock on wood. I don't know if you've had that happen, David, but they're definitely doing it, so be worried about that too.
Yeah, I haven't seen it yet in practice, but it's coming. I mean, I think Karen's point about the app on the web shows that, to Brian's point, they're looking for money, and the easier that they can make it for employees or for individuals to identify these types of issues and assemble the information for them from the government's perspective, that's an efficient system. So I think we are going to see more, cross-pollination of information. That being said, the government's a large, very complex organization. organization, so it doesn't always share information as fast as it would like to. But I think the fact that they are trying to, and they are saying that they are going to, is again, a major development on this front.
Mm-hmm. And any governor will tell you the states are hurting more than the federal government. True or not, they certainly feel that way. And so the states are in the act too. We have just a couple of examples here. Connecticut, some of the local jurisdictions, New York, have created their own either acts they've already passed, as in the case of Maryland, for example, or in Virginia. I can't remember if we mentioned this earlier. Virginia has a very similar statute to, or bill, similar to Maryland's statute in terms of making it a presumption of employment and increasing fines and things for that. That was introduced in 2010, didn't pass in 2010, but it's back, at least last time I checked, has not passed yet, but it's still, I believe, in committee in the Virginia legislature. Connecticut dropped a $300 per violation provision into a law it passed regarding misclassification, where if anybody is found to have intentionally misclassified a worker to avoid unemployment comp or to otherwise defraud or deceive the government, whatever that means. So anybody on the phone from Connecticut, congratulations, you're in there as well. Very briefly, and then we'll turn back to Dave, Ss8 Determinations. There's a document actually in everybody's materials that's a several, I think about a 4-page form by the IRS called Ss8. This is something that's not new, but it's still there and you should be aware of it. Oftentimes, you can end up in a situation with the IRS in particular, although as we said, work sharing agreement, so everyone comes on board, but you end up with a tax problem because one of your employees has a tax problem. Maybe at the end of the year, Brian Hudson is paying, he's 1099, he's your independent contractor. He starts to think about this big tax bill he's paying, and he asks the IRS agent, shouldn't I be an employee? The IRS agent can begin this Ss8 process using this form. The agents can also do it kind of independently on their own. They let the organization know when that happens. They're supposed to. And it's not technically binding on the rest of the organization, the rest of the entity. But, and I should mention very quickly, one of our partners, Lisa Tavares, who's in our employee benefits group, helped pull together some of this tax-related information. So I'd be remiss if I didn't give her some credit. She's worked, I think, with Jeff quite a bit, and probably with some of y'all. But the Ss8 process, even if it's not binding, it's certainly, if Brian Hudson is found in this IRS audit of him through the Ss8 process to be an employee, and IRS then sees, hey, and there's 30 Brian Hudsons at this organization, you can expect another knock on your door. The form is interesting to look at. We included that just because, again, kind of like with using the 20-part test, the questions the form asks are useful for your own purposes. Number 9 on page 1, did the worker perform services for the firm in any capacity before providing services that are subject? Kind of goes to what we talked about before. Have you been here before? On page 2, you have the behavioral control, the financial control that we talked about earlier, and the questions. What specific training or instruction is the worker given? Number 10, if substitutes or helpers are needed, who hires them? Under part 3, number 4, specify which, if any, expenses are reimbursed by. This gives you an idea of what the IRS is looking at, because you can bet in an audit of you that's outside the Ss8 process, these are the same kinds of questions they'll be asking themselves as they look at your documents and asking you directly. So it's a useful tool, I think, to have as kind of the latest roadmap, if you will. And with that, I want to skip it back over to David to talk a little bit about what happens next.
Yeah, just one last word on the Ss8 document. Brian's right. When you're looking on the web for information about independent contractor or employee status, you still will see a lot of this IRS 20-factor test. It's still a helpful tool, a helpful metric, but really walking through the Ss8 form, that's the information that the IRS agents are gathering, and that really lays out the facts for you if you're doing the analysis yourself. It's a very helpful tool. So ultimately, the question is going to reduce to, is worker X an employee or an independent contractor? And the consequences of getting that wrong can be extremely significant, as we've touched on a few times today. It brings into issues of back taxes, back pay and overtime, and other liabilities related to both federal and state laws. The issue that I think everyone latches onto at first, because it's often the IRS raising these issues, is back taxes. And there we're talking Social Security and Medicare, so your FICA, unemployment insurance trust, FUTA, that should have been withheld, that they're going to be looking for. There's up to a 10% penalty for failure to pay those, which is almost always applicable because it starts at, I believe, 2% and climbs to 10% based upon how much delay there was in the time that those payments should have been made. But it gets to 10% in 10 days. So very typically, that 10-day trigger has long since passed by the time. So you're looking at those payments plus 10%. But in my mind, the back taxes issue really isn't the most significant one. Where we see real exposure to clients is on the benefits issue. Because think of it this way, if you have an individual in your workforce that you're calling an independent contractor, and that status gets challenged and falls, and that person was an employee, if they met the definition of a participant or a plan participant in your health insurance, if it's defined to include employees, which they typically are, that person has been entitled to insurance the entire time that they were in your organization and can make a claim for that benefit. Obviously, healthcare and medical expenses can be huge exposure, particularly for smaller organizations that may not be able to withstand a very large hit, particularly in these very difficult economic times in the not-for-profit space and otherwise. Overtime and back pay is another one. As Karen pointed out, we've got the DOL with the handy hours tracker to make certain that you can find out how much overtime that you are owed. As an independent contractor, you're not entitled to overtime. Employee, time and a half for any hours over 40. And in not-for-profit sector, we often have employees that work very long hours, particularly during times of annual conferences and the like. Fair Labor Standards Act has a 2-year look-back, 3 years for a willful violation. If you have someone who's a relatively highly compensated consultant, now Brian's infected me with the air quotes, that can really add up very quickly. The other thing, they're entitled to coverage under Title VII and other EEO laws. So if you were terminating a contract and they were truly an employee, they can actually assert a claim for employment discrimination like any of your employees could. The other hidden issue here is that particularly for entities that use independent contractors to scale up their workforce very quickly, is that if your independent contractors are counted as employees, you could find yourself triggering coverage under various federal statutes. So if you're a small employer and have less than 15 employees, let's say you have 12 employees and 3 independent contractors. If you misclassify the 3 independent contractors, you actually now have 15 employees, which means you're subject to Title VII, the ADA. For larger employers, it's very easy and conceivable to push yourself up into the FMLA, the 50-employee trigger. So the independent contractor status, when it's done wrong, has a tendency to cascade into a number of issues. And that's why it's something that our friends on the plaintiff's bar often look to, because once you've triggered that, once you've flipped that status, it implicates any number of issues. And there is some relief, though. Oh, I'm sorry, we have a question. I'm not certain. I don't know if you've...
Yeah. There is potential liability for those who are, personal liability for those who are in charge of overseeing that the IRS can and does enforce. In fact, we had a case where that happened with one of our nonprofits. I don't remember all the particulars offhand about exactly when someone can be held responsible, but it is something that you definitely need to be cognizant of.
Yeah, it's an excellent point, Karen. And for those of you who are not here in person, our partner Karen Pass was mentioning the 403B issue, which is another, obviously, very oftentimes, particularly in the not-for-profit and association world, can be a very rich benefit that's provided to employees and matching contributions. And we have a matter going on now where this issue has been raised. An individual was misclassified, should have been treated as an employee. and the employer is being required to make the matching contributions for this individual as if they had made the maximum contributions throughout their entire employment with the not-for-profit. So again, it's another area where, although again, I see many people tend to focus on the tax implications, that it's really the benefits implications where the real dollars can add up here.
Real quickly, I know we're running a little short on time. I want to make sure we have time to tell you some suggestions for what you can do about it and save time for questions. Section 530 of the Revenue Act, what I want to say about that is it's basically grandfathering. It's a 30-some-odd-year-old provision that was never intended to be permanent, but stays and it sort of takes the place of these tests under, at least as far as the IRS goes, if you meet a couple of criteria. And those criteria are listed: the reasonable basis, substantive consistency, and the reporting requirements. One quick thing about Section 530, it's in the budget this year, has been in the budget in the past to do away with it. There have been bills put in to do away with it. It's always sort of at the edges of its usefulness, but manages to survive this exemption, basically. Reasonable basis means if you call this worker an independent contractor but had a reasonable basis for doing so based on a previous IRS audit, a court case, advice of counsel, industry practice, then you meet the reasonable basis. The substantive consistency, do you have all of the workers who are similarly situated, are they all treated the same? Are they all treated as independent contractors? Are they all 1099'd? You don't have some who are getting W-2s. The reporting consistency piece. If they meet those factors, then it's possible that the Section 530 relief is available. So in case of an IRS audit in particular, because, again, this Section 530 seems to come and go in viability, it's definitely something to discuss with your counsel, with your experts, if it happens, to see, is this something that's still available? Is it an avenue that we can use if we don't feel comfortable under the three-factor test, the 20-prong test, et cetera? And with that, I think we can skip forward to ask David, what the heck do we do about all this?
A quick word on Section 530. My experience has been that section sort of like agreements to indemnify. If that's the issue that you're dealing with, you've already have a whole host of problems. So really, you don't want to be in the position of having to argue for 530 relief. Really what you want to do is be proactive on these types of issues, and the primary defense mechanism here is the self-audit, to take an honest assessment of your independent contractor relationships and say, okay, which ones do we feel strongly about, which ones are on the border, which ones may have just simply gotten wrong. And in any of these circumstances, a primary building block of having a defensible independent contractor relationship is going to be a very strong written contract. And Brian will talk about those in a moment. We've talked about throughout the day a couple of the common problems that we see, or the issues where these arise. The retiree who's really just throttled back a little bit, largely performing the same duties in the same position, but for convenience or because they've relocated and we don't want to have to register to do business in another state, we just call them a 1099 independent contractor. Similarly, the former employees at lower levels. Current employees working in a second capacity. It can happen. You can have employees that have side businesses that they want to contract with you. It's a definite red flag if you've got a single individual who in a given year gets both a W-2 and a 1099 from your organization. That's something that's going to be noted by the IRS if they're auditing you. And we already talked about the independent contractors who are in management or supervisory roles, aside from a management services agreement or interim CEO and CFO. Another one that I didn't add here, and it struck me this morning, is what I like to refer to as the permanent temp. Oftentimes you'll have someone say, well, we want to hire Jane because we have the annual meeting coming up, we need some extra hands, she'll just be here for 3 months. And Jane comes in, sets the world on fire, and 3 months becomes 6, becomes 12, becomes 18, and she's working side by side with all of your employees. She's never raised the issue, and suddenly, you're calling her a temp employee, and she's been temping for the last 2 years. That's going to be a problem, and that's one that we see happen a lot, I would say typically in larger organizations where some of these things can get lost, but it is something to look at. If you have someone who you're just a temp hire that you just want to do on a 1099, if that person stays around, make sure that you convert them, if it's appropriate to convert them to a W-2. Now, in terms of cleaning up, what do we do if we have issues? The first point is that you don't have an obligation to throw yourself at the feet of the IRS and incriminate yourself and say that we've been doing this wrong. Because as we said before, there's a world of gray between those two very clear poles of the legal assistant and the yard service. And reasonable people can disagree within in that gray area. But if we think that we do have an issue, or if we might be incurring a bit more risk than we would like to, what are some tools that we can use? The first suggestion is to not modify the relationship, if you can, mid-year, so that you don't have a circumstance where someone's going to get both a W-2 and a 1099 from your organization. So unless you've got real clear risk here, I'd say identify it, flag it as an issue, and then convert them in the first of the year so that they would just transition from a 1099 to a W-2. We also recommend that something else happen at that same time, that you either modify the position or can put some additional context into it with regard to the employee, aside from just saying, wow, we really screwed this up, and here on out you'll be paid on a W-2. You can dress it up as a promotion, as a transfer, as congratulations, you are now benefits eligible, but to provide some context for them so that they can have an understanding as to why I'm now benefits eligible. And it's often times people that you're going to want to retain them in your organization, so they tend to be good performers anyway. And it doesn't have to be a doubling of their salary, or the doubling of their pay, but some context so that they can see, and we can explain down the road, here's why we thought that they were 1099 before. Now they're getting more responsibility within the organization, and that's why they were converted. And with that, I'll turn it over to Brian for a few words on the agreements themselves.
Most important thing I can say about the independent contractor agreements, have them and follow them. It's easy, very easy, to create them and then put them in a drawer somewhere and go back to the way things were. And that won't help you, unfortunately, very much. We have several issues listed here, but ideally, this is an ideal world. Let me start right there. Some of these just won't work for you practically. But to the extent you can, have independent contractor agreements that are in writing that touch all the things we talked about, that are discrete, project-based, that you don't provide the significant training that indicates the independent contractor is just that, is able to hold themselves out and work for other organizations. You definitely don't want, as I've seen recently, an independent contractor agreement that says you may not work for anyone else. To provide their own tools, the freedom to contract, all those type issues. I want to save a couple minutes for questions, so I won't read through every one of these. But again, the important point is having that and then enforcing it. The point of having it is that it gives you sort of your Bible and gives the worker their Bible for the relationship, that you're not controlled, here's your compensation, which ideally is not hourly, but is a project base, for example, and you are giving us a product, and that's what the contract is for. It's terminable only because of non-performance on either part or at the end of a set period, the conclusion of performance, for example.
And it's a very good idea, and a lot of our clients do it, for you to have kind of a model independent contractor agreement, or maybe several versions of it, kind of as a stock form document that you use as a starting point. Of course, each one has to be tailored to each particular situation, but we find there tends to be a lot better documentation of these relationships when you have a good form agreement that's been reviewed by counsel that does all these things that Brian just pointed out. It makes for a great starting point.
One more comment. I think it's great advice to have an agreement, but I wonder if the real value is in establishing mutual understandings between the organization and the independent contractor. One of my member organizations recently was subjected to a state audit, and the auditor didn't even want to look at the agreement. So it was strictly on facts and circumstances of what was going on.
Yeah, and that's a great point. That's why Brian said have your agreements and then follow them. You're right. A great agreement isn't going to mean anything if the actual relationship is very different. If it has all the right language in there, but then you have a bunch of negative factors, it's really not going to matter. So you have to you're exactly right. You need to make sure you're on the same page with a contractor at the outset. put it all into the agreement, make sure they agree to it, and then follow it consistently.
And I think the point that you make about mutuality of understanding is essential as well. Because what you don't want to be in a circumstance of having the worker saying credibly, I had no idea. I mean, I thought I was an employee. And that's where the written agreements can come in handy. So. Other questions?
We have a question from the phone. What's the possibility for retaliation against an employee who files for an Ss8 determination with the IRS?
It's an interesting question. I had not had to address that issue, but I would assume that there are anti-retaliation provisions that would apply. And I would tell you, even if there's not, I would suggest that would be a bad course of action to retaliate against someone solely for asking the IRS for determination, because they have a right under the statutes, and the IRS pushes that information towards employees that says, if you question your status, here's what you do, here's the form that you fill out, here's where you send it. There's no upside to making an enemy of the Internal Revenue Service.
I was going to say no good can come of that regard.
Any other questions from here in the room before we wrap up? And I'm going to open the phone lines so people can ask questions on the phone too. Yep, back here.
Any words of wisdom now that it's becoming an internship?
You want to repeat the question? Yeah, the question was any words of wisdom now that it's becoming internship season. There's an article that's available at our website. The rules around unpaid internship have recently been modified. When the Department of Labor issued, I think it was a Q&A or a fact sheet that it came, I can't recall the exact format, but it dealt with what an unpaid internship looks like. They were very specific in saying that they were looking at the relationship in the for-profit world. But then they dropped a footnote that suggested that they're not necessarily telling people that the analysis would be any different in the not-for-profit world. There's not saying that they didn't make any specific statements in that regard. It's just said that this is limited to this is a for-profit and for withholding comment on the not-for-profit. In the for-profit world, the unpaid internship is almost extinct, except in the context where it's tied to an educational program and an educational institution, because there's rules about if the employer is gaining virtually anything of value out of the relationship, there's a strong argument that person is an employee and should be getting paid.
Another question here.
I think you touched on this when you talked about insurance, CEO, and CFO contracts. But is there some guideline that distinguishes between a contractor versus an outsourcing, or with outsourcing you consider, say for example, the function of payroll or meeting management is completely outsourced for whatever period of time?
Yeah, as always, it will depend. Oh yeah, I'm sorry. The question was, we had mentioned about interim CEO and CFO and how that relates to the issue of outsourcing and outsourcing particular functions. And I think payroll processing is a good one, because you have outfits like ADP where you can simply outsource the entire function, and what you do is you cut them a check and they run the whole thing. Now, if what you used to have was a payroll clerk that did all that for you, and now they want to go out and they say, well, I don't want to work here anymore, I'm relocating, I still want the income, I'll just do it and just pay me on a 1099. In one perspective, you've outsourced it because it's now being done by someone who's not your employee, but highly likely that person's still your employee. So it really does depend upon the nature of the outsourcing.
Yeah, contrast that to kind of a lot of associations will outsource some or all of their accounting function, or some or all of their HR function. We have a lot of our clients that do that, and there's a lot of CPA firms and others, HR firms that serve that function around town. But in those situations, these are companies that do that for part of their business, and they do it for lots of different clients. So even if it's a permanent relationship, generally speaking, all of the other factors are going to point in the favor of an independent contractor relationship. But I'm sure there's definitely some situations in that regard, even in those kind of situations, where depending on if one particular employee, is at that, job site for so long and really is treated like an employee in every other respect, I would assume, Dave, that may raise some issues down the road.
Yeah, no, absolutely.
And if you have a relationship with an ADP or an HR type function, and then you have a worker who's in a gray area, you can compare the two, and you'll see, how many ADP hits every one of those that we've talked about today, all the factors, the control all the way down, and you can see how they match up.
We have we're going to have to wrap this up, but final question from the folks on the phone. Is there any distinction? We talked about unpaid interns and nonprofits, and you kind of addressed that. And like Dave said, there is an article on our website about that specific issue. But is there any distinction between an unpaid intern and, say, volunteers? Nonprofits heavily rely on volunteers to do a lot of their work. Is there ever a situation where a volunteer, not an intern, but a member or other volunteer, could rise to the level of becoming a potential employee?
I'll start because I'm going to almost immediately turn left and look at David. And again, it depends, I think. It's the nature of what the person, not even a worker, that the volunteer is doing for you is my first take on it. And what their function is, how integral they are to the process, and sort of looking at how much are they like an employee, which is a long way of saying it depends. But David, do you have more experience on that?
Yeah, no, I think that's right, Brian. That there is more of a window of opportunity to have volunteers in a not-for-profit space than in a for-profit space. But ultimately, if what you have is a circumstance where a member or a volunteer is replacing work that would otherwise be done by a paid employee, that's going to raise potential issues. So, again, if all those indicia are there, that it's a permanent relationship, that they really are integral to the workforce, I could easily see the Unemployment Commission or others, DOL, looking at that relationship and saying this is not someone who's volunteering for the sake of it. This is someone who's helping you run your business and should be getting compensated.
And one more kind of twist on that. What if you have officers or directors, typically officers? In some nonprofits, it's not the norm by any means, but there are some nonprofits where officers get some compensation for the work that they do. And they may spend, they may have another day job, but they may spend 50% of their time, serving as the president or the chairman of the organization. Does that raise any potential issues in your mind?
It would. It could. I would hate to say it depends for the 1,000th time today, but certainly to the extent that you have people who are providing services to the organization and being compensated for them. I mean, there are some organizations that provide stipends and the like, and that's very common. But if you have someone who's really replacing an individual or replacing a slot that would otherwise be done by a paid employee, the Department of Labor has shown time and again that they look at those with a great deal of scrutiny.
Great. Well, thank you, Dave. Thank you, Brian, for a terrific presentation. Thanks all of you for participating, and enjoy the rest of your day. Thanks.
Thank you.
Thank you. Please stand by.